Hello, this is Captain Chaudhari. Today I'm going to discuss the difference between the Hamburg Rules and the Hague Visby Rules. This cannot be finished in one video, so I'll be doing it in a couple of videos, but in this video, basically, I'm going to talk about the difference between the concept of bills of lading in the two rules. Now, when we talk about the bills of lading, it is closely connected to the definition of carrier and contract of carriage. So we will also be talking about the definition of carrier in the two rules, and also what is contract of carriage in the two rules. What is the relationship between the bills of lading and contract of carriage, right? When we talk about the Hamburg Rules and Hague Visby Rules. So let us first understand what is carrier in Hamburg Rule. Carrier means a person who concludes the contract with shipper, on whose name the contract is finally concluded with the carrier. As you know, in contract there are two parties. One of the parties is shipper, the other party is the carrier. So this person may not be actually the shipping company. He might be having an office in a remote area, not at the port, but he concludes the contract with the shipper or the farmer. Then the rules also define actual carrier. Actual carrier is a person upon whom the responsibility of performance of carriage of goods is entrusted. So there is a carrier and there is this actual carrier. Whereas in Hague Visby Rule, they don't talk about the carrier and actual carrier. In Hague Visby Rule, it says that it includes the ship owner or the charterer. It means that in Hague Visby Rule, they generally mean that the carrier is either the ship owner or the charterer. Now let us understand what is contract of carriage. Contract of carriage in Hamburg Rules is a contract whereby the carrier undertakes to carry the cargo, the carriage of goods from one port to another port. This carriage is upon payment of the freight. That's one thing. That means it is undertaking of carriage of goods from one port to other port upon payment of freight. Additionally, it also involves the carriage of goods by sea. You may have a contract of carriage which involves the other means of carriage, but Hamburg Rule pertains to only the portion in which the carriage is by sea. In the Hague Visby Rule, it says that the contract of carriage applies to the bills of lading or similar document of title. It also applies to the bills of lading or similar document of title which are issued pursuant to charter party. So that is the importance of bills of lading in Hague Visby Rule. So can we say Hague Visby Rules apply to the bills of lading, whereas Hamburg Rules don't apply to the bills of lading. Hamburg Rules apply to the contract of carriage. In Hamburg Rules also it is very important that the carrier issues the bills of lading to the shipper. So the Hague Visby Rules will apply even to the document of title or bills of lading issued pursuant to the charter party. And the interesting thing is, even if the bills of lading is not yet issued, we know that the bills of lading is issued at the last moment when the cargo completes, at the completion of the cargo. But even if the cargo work is going on, the cargo is not yet completed, the bills of lading is not issued yet. But even if it is decided that the Hague Visby Rules are to be applied, if it is decided that the bills of lading will be issued, then even if the bills of lading are not yet issued, the rules can apply. Article 14 of Hamburg Rule says that it is the responsibility of the carrier to issue the bills of lading to the shipper upon demand, and the carrier must issue the bills of lading. It can be issued by the carrier or a person who is authorized by the carrier. The person who is authorized by the carrier could be the master, as is stated in Hamburg Rules. Now, on the other hand, let's look at what Hague Visby Rule says. Hague Visby Rule says that when the goods are received in charge, then the carrier, the master, or the agent of the carrier can issue the bills of lading or must issue the bills of lading on demand by the shipper. Now, as per Article 15.1 of Hamburg Rules, there are these cargo related and the other particulars which must be entered in the bills of lading. But 15.2 says that in addition to the 15.1 related entries, additionally when the cargo or the goods have actually been loaded on the ship. If the shipper demands, it is the responsibility of the carrier. It is the responsibility of carrier to issue the shipped bills of lading. And the shipped bills of lading will have additional information that the cargo is loaded on such and such ships and on such and such date. Now, prior to issuing of the shipped bills of lading, there is a possibility that another bills of lading or document of title was given to the shipper. Then what the shipper should do is, the shipper should surrender that earlier document of title to the carrier, when he gets the shipped bills of lading. Alternately, that earlier bills of lading which was given, or the document of title which was given, that can be amended, that can be modified with the required entries, and that document can be made as shipped bills of lading. Now, Article 3, Paragraph 7 of Hague Visby Rules says more or less the same thing. It says that once the goods are loaded on board, upon the demand of shipper, it is the responsibility of the carrier master or carrier's agent, to issue the shipped bills of lading. Alternately, if there was another document of title, issued prior to the issue of shipped bills of lading, the shipper must surrender that document. Alternately, that earlier document could be noted with the port of loading and the date of completion of loading, and that earlier document can be considered as shipped bills of lading. Now let us try and understand what is bills of lading. In the Hamburg Rules, the definition number 7 of Article 1 is bills of lading. There are three things which are stated in defining the bills of lading, and we must understand. The first thing is, it's a document which evidences the contract of carriage. So it is an evidence to the contract of carriage. So it says that, indirectly it implies that it is not contract by itself, it is evidence to the contract of carriage. It also evidences the loading or taking over of the goods by the carrier, of course. And the third thing, it is something by which the carrier undertakes to deliver the goods upon the surrender of bills of lading. Right? It is like a bills of lading surrender and the cargo or the goods are delivered to the receiver. So that is what is bills of lading. However, if we look at the Hague Visby rule, there is no specific definition in the bills of lading. Right? So the first article, which defines so many things, does not define bills of lading. But bills of lading is so important in Hague Visby rules. It is implied. The meaning is implied in Hague Visby rule. So the meaning is implied by the definition of contract of carriage. It is also implied by the explanation or the clause that is given in Article 3, Paragraph 3 and 4. There is a great reliability that is placed on the content of bills of lading. So there is a great responsibility upon the carrier or the person who signs the bills of lading. However, there are situations whereby the master does not exactly know as to what is the condition of cargo inside, say, a container, or what is the quantity, what is the real quantity. So let's talk about such situation and let's see how the two rules deal with a situation like this. Article 16/1 of the Hamburg Rules says, if the bills of lading contains particulars concerning the general nature, leading marks, number of packages, of pieces, weight or quantity of the goods, which the carrier or the other person issuing the bills of lading on his behalf knows or has reasonable grounds to suspect, do not accurately represent the goods actually taken over, or where a shipped bills of lading is issued, loaded, or if he has no reasonable means of checking such particulars, the carrier or such other person must insert in the bills of lading a reservation specifying these inaccuracies, ground of suspicion, or the absence of reasonable means of checking. Article 3/3 of Hague Visby Rule says, provided that no carrier, master, or agent of the carrier shall be bound to state or show in the bills of lading any marks, number, quantity, or weight which he has reasonable ground for suspecting not accurately to represent the goods actually received, or which he had no reasonable means of checking. So we have seen there is a difference between the Hamburg Rule and Hague Visby Rule. In Hamburg Rule, the carrier must insert a remark in respect of reservation, whereas in Hague Visby Rule, the carrier is not bound to enter any such remark. Hamburg Rules specifically talk about the evidentiary effect of the bills of lading. In Article 16/3, it says, in absence of reservation entered, A. The bills of lading is prima facie evidence of the taking over, or where a shipped bills of lading is issued, loading by the carrier of the goods as described in the bills of lading, and B. Proof to the contrary by the carrier is not admissible if the bills of lading has been transferred to a third party, including a consignee who in good faith has acted in reliance on the description of the goods therein. Article 3, para 4 of the bills of lading says similar thing. It says that the bills of lading is prima facie evidence of the receipt of the goods in the condition the way they are stated in the bills of lading. It goes on to say, however, proof to the contrary is not admissible when the bills of lading is transferred in the hands of a third party acting in good faith. Which means that one cannot mislead the receiver who has acted in good faith, who has paid the money. He expects the goods to be in the condition as they are stated in the bills of lading. Now let us look at the financial implications. The person who's signing bills of lading, he has great responsibility about the accuracy of the information that is provided in the bills of lading. We have to understand that there is a third party who has acted in good faith. He is going to rely on the information that is stated in the bills of lading. Imagine the third party or the receiver, when he receives the cargo, he looks at the bills of lading and it is stated there that he is not required to pay any demurrage, or he is not required to pay any freight, or if it is stated there that freight is payable by the receiver, freight is payable by the consignee, or the consignee is supposed to pay the demurrage. So there are a lot of financial implications, and it seems the proof to the contrary to what is stated in the bills of lading, is not admissible. Now this particular thing is specially mentioned in the Hamburg Rules. Hague Visby Rule does not directly talk about such a thing, but Hague Visby Rules do talk about, the evidence to the proof to the contrary is not admissible, which means that even in Hague Visby, even under Hague Visby Rule, when there is some entry made in respect of freight payable or the damage payable, etc., it is the duty of master to confirm the same thing with the owners, whether the information is correct or this information should be changed. Clean bills of lading 16/2 says that if the carrier fails to put any remark, or he simply issues the clean bills of lading without any remark, it would be assumed that the cargo was received in good condition, good order. Whereas Hague Visby Rules specifically don't talk about such a thing, but no adverse remark in respect of the condition of cargo or the packaging would imply that the cargo was received in apparent good order. Article 14/2 of Hamburg Rules says that the bills of lading can be signed by carrier or a person who is authorized by the carrier, and master, when he signs the bills of lading, is assumed to be a person who is authorized by the carrier. Article 14/3, the signature on the bills of lading may be in handwriting, printed in facsimile, perforated, stamped, in symbols, or made by any other mechanical or electronic means, if not inconsistent with the law of the country where the bills of lading is issued. In Hague Visby Rule, it says that the bills of lading is issued by carrier or the master or carrier's agent. Now let us see how the cargo is described in the bills of lading under Hamburg Rules and under Hague Visby Rule. What is specified in the rules in respect of description of the cargo? Let's look at the Hamburg Rules first. Article 15.1 A. It says that the general nature of the goods, the leading marks necessary for identification of the goods, an express statement, if applicable, as to the dangerous character of the goods, the number of packages or pieces, and the weight of the goods or their quantity otherwise expressed, all such particulars as furnished by the shipper. Article 15.1b, it says that it also should describe the apparent condition of the goods. Let us see what is stated in Hague Visby Rule. Article 3, paragraph 3a, it says that the description of the cargo would be the leading marks necessary for identification of the goods as the same are furnished in writing by the shipper before the loading of such goods starts. Stamp should ordinarily remain legible until the end of the voyage. Article 3, paragraph 3b says either the number of packages or pieces or the quantity or weight as the case may be as furnished in writing by the shipper. C, it says the apparent order and condition of the goods. Now this was the cargo related information that is supposed to be entered in the bills of lading as per the Hamburg Rules and as per the Hague Visby Rules. But when we look at the bills of lading, there is a lot of other information. For example, port of loading, the consignee, consignor, etc. Now, the other information, other than the cargo related information, in the Hamburg Rule, under the Hamburg Rules, it is specified in Article 15. And what is that information? Let us look at it. 15C is carrier and place of business. D is the name of the shipper. 15E, the consignee if named by the shipper. 15F, the port of loading under contract of carriage by sea, date, goods taken over at the port of loading. 15G, the port of discharge under the contract of carriage by sea. 15H is original bills of lading, the number of original bills of lading if more than one. 15I is the place of issuance of the bills of lading. 15J, the signature of the carrier or a person acting on his behalf. 15J, the signature of the carrier or a person acting on his behalf. 15K is the freight payable by the consignee. 15L, the statement that the carriage is subject to the provisions of Hamburg Convention. 15M, if the goods shall or may be carried on deck. 15N is the date or the period of delivery if expressly agreed. 15O, any increased limit of liability if agreed. These additional information are specified only under the Hamburg Rules. Now we have seen what is the cargo related information and what is that additional information that should be there in the bills of lading. But it is possible that by mistake or by construction of the bills of lading, some of these information is missing. So is the bills of lading invalid? So what is stated in Hamburg Rules in respect of a situation where certain information is missing? So it says the absence in the bills of lading of one or more particulars referred to in this article does not affect the legal character of the documents as a bill of lading, provided that it nevertheless meets the requirements set out in the definition of bills of lading. Now earlier we saw the definition of bills of lading. There are three important constituents in the bills of lading definition. As long as those conditions, that criteria is satisfied, the bills of lading is still valid, even if certain information that is specified under Hamburg Rules is missing in the bills of lading. Now one last thing needs to be discussed in respect of documentation when it comes to Hamburg Rules and also when it comes to Hague Visby Rules, and that is the document other than the bills of lading. Let us see what Hamburg Rule says in respect of a document which is not bills of lading. So it says in Article 18, where a carrier issues a document other than a bills of lading to evidence the receipt of goods to be carried, such a document is prima facie evidence of the conclusion of the contract of carriage by sea and the taking over by the carrier of the goods as therein stated. Under Hague Visby Rule, the definition of contract of carriage validates such similar document of title insofar as such document relates to the carriage of goods by water, including the document of title issued pursuant to a charter party.